Okay, so we're now into the first core issue we want to talk about in terms of what does GDPR really mean for HR data, and that's going to be focusing on issues of transparency, consent, and legitimacy. And so as we know, the way GDPR is set up, European General Data Protection Regulation, you can think of, as my German colleagues like to say, everything is prohibited unless it's permitted, okay? So you have to think the default is you're not supposed to be doing anything unless you're allowed to do something. And the first step in being allowed to do anything is one of transparency. And so we know that GDPR contains a lot more notice requirements than were there before in terms of articulating not just what's happening with collection, use, disclosure, and transfer, but also articulating the rights that individual employees are going to have with respect to their information. And so you can assume that part of this process is going to be a repapering of your notices to employees on privacy. But then what about consent? Now, we've known for years that the privacy authorities don't like consent in the employment context because they view it as being coerced. You're the big bad employer, if I can say it that way. You're the big bad employer. They have no leverage against you. So if you get a consent, it's going to be deemed to be coerced and therefore not valid consent. But at the same time, we know that there's some pretty strict rules around how do we actually meet other bases for handling information. And I think if you boil it down, you're pretty much going to want to be making sure a couple things. One is thinking in terms of data minimization, meaning only collecting data we need for the specific purposes and not over collecting data. That's a basic rule of hygiene here in this area. Another one is going to be you're really going to try to rely on legitimate purpose, legitimate business purpose, and other grounds for necessary to perform the employment contract, and try to avoid reliance on consent as a basis to do any processing. Why? Because we've got still the threat that it'll be deemed coerced. But also, in reality, if you're getting consent, then in theory they could withdraw their consent. And then you would be, what would you do at that point? Would you have to go and clean out the data or restrict its processing, et cetera? So we can still envision that there may be a few instances where consent is going to be needed or helpful, and that correlates to what the current law tends to result in, which is if there's a stock option plan that you have, it truly is optional. The employee can or cannot choose to give a consent to the data sharing with whatever financial institution is going to be actually executing on the stock option. So consent there is typically baked into the plan. Things that truly are optional, like healthy balance programs, or things where you're giving people options to get some extra resources that truly are optional, is another area. So there's at least a few discrete areas where maybe consent is going to be relevant, but mostly you're going to be relying on transparency, data minimization, and just legitimate interest. There's another kind of sleeper category of issue that I also should mention, which is when you get into that phase of compliance or monitoring activities, if you're doing something like a data loss prevention tool, you have to be attentive to how you roll it out so that you don't, for example, slip into a profiling activity and something that itself would trigger some consent duties. And how do you do that? Well, you can destroy the need to get consent even for profiling if you don't just rely on automated means to reach some kind of results that affect an employee. So for example, if you roll out a data loss prevention tool, be mindful of how much you calibrate it, but don't do silly things like automatically trigger a notice to an employee that they're doing something wrong without having a human review of it. So you kind of get out of the automated space exclusively and help avoid the application. So the bottom line there is just be sensitive and thoughtful about how you roll out monitoring issues to try to avoid consent wherever possible.